All right, the court. All right, the next item is the defense motion to exclude computer-generated animations. Attorney Strang, I'm sorry, before we go to that, I think we need a ruling from the court on whether it's reconsidering its earlier order that fingerprint testing had to be completed before the state removes the blood vial for EDTA testing. The court. I'm going to allow the FBI to make that decision for the reasons that I don't have the scientific knowledge to know the significance of one being done before the other. If the FBI acts in some way that either the fingerprint evidence or the blood evidence results are compromised, I assume that the defense expert can address that. We do have notice of defense experts that will be testifying and criticizing, in some respects, the methods that were used by the state to produce test results. So I'm not going to specify the order in which the tests are conducted. Attorney Gahn. Your Honor, I must get back to Milwaukee. May I have leave of the court to go? The court. Yes. Attorney Gahn. Thank you, Judge. The court. All right, we'll move on then to the defense motion to exclude computer-generated animations. Attorney Kratz. Judge, from a timing standpoint, I do recognize that we have 6 or 7 different matters to hear. We have witnesses, or a witness that is standing by from the State Patrol. He's also been kind enough to prepare for the defense and for the court documents which set forth his methodology in the creation of demonstrative evidence. Those include the scene models that we talked about, include both interior models of the defendant's trailer and garage, as well as the exterior overviews of the Avery property. He also deals in second set of explanations for the court, some information regarding skeletal models, and is prepared to provide testimony as to animations. I believe that Mr. Strang had expressed at least the most serious objection, and I'm sure he will correct me if I'm wrong, but the most serious objection to actual moving images. But having made those prefatory comments, Judge, since Mr. Austin's testimony is not only likely to mirror that I provided the court now in writing, although there may be some additional information, Mr. Strang and I, in correspondence before this hearing, recognize that final decisions on admissibility will need to come closer in time to the trial or during the trial. I'm wondering if the court wishes to review the written submissions. I could make for the court and Mr. Strang copies of the DVDs, that is, the animations themselves. That will give the court a fair understanding of what we're talking about, and perhaps in the interest of getting through some of these other issues that, frankly, need to be decided before Monday, it's my recommendation that we do that. Because this, even with Mr. Strang's opinion, and please, Mr. Strang, correct me if you think I'm wrong, but this is something that probably can wait until we get into trial or closer to trial, and necessarily, in some instances, must wait for that. I will do it now, Judge, and I'm happy to present this. In all candor, this may take the better part of an hour to present the offer of proof and our explanation of these demonstrative exhibits, and I'm certainly, as I mentioned, happy to proceed. But I do note on our agenda there are things that, quite frankly, have to be decided today before we move into the balance of jury selection on Monday. The court. All right, Mr. Strang? Attorney Strang. In the main, Mr. Kratz is right. We can't conclude this issue today, even if we start it, because the court will need to take some testimony from Trooper Austin while he is physically here, present, and able to show things to me, at least, and to the court, at least the two of us. He's probably shown these things to counsel for the state before, so we could get started by telephone, but couldn't finish. I also note that in the 3 new memoranda that Mr. Kratz gave us, and I think I gave the court, each of the 3 dated January 29th, 2007. The thinnest of those memoranda is entitled New Model Renderings, and this includes things that are altogether new, that I haven't seen before and I didn't know were coming. Probably the most significant being number 3 on page 1 of the January 29, 2007 memorandum entitled New Model Renderings. So, if it would take an hour of testimony for the state to do its direct examination and its proffer, we're probably talking about an hour of cross-examination and wouldn't finish the issue today in any event. So I think I land where Mr. Kratz does. Just probably the better thing to do is to move to other issues today and address this, I guess, during trial or Attorney Kratz. What I can also do, I'm sorry to interrupt, Mr. Strang. What I could also do, Judge, is perhaps show the court and counsel the animation that's been performed. That's something that you don't have, and that's the moving part. So that at least you can get an idea of what we're going to be talking about. I'll be happy to make both the court and counsel copies of those finished products, and would have anyway before we seek to admit them. That will only take probably 5 minutes or even less. And then my suggestion is to move on to the next item on the agenda. I will call Trooper Austin and apologize since he's been waiting since 1 o'clock. But that just seems practical to me. The court. So you have a 5-minute presentation? Attorney Kratz. Even less, yeah. The court. All right, well, it will. I have already looked at the loose leaf you gave before on the computer screen, which I assume duplicate the information in the loose leaf. I will take a look at this now, and then we'll move on to the next item. Attorney Kratz. While the projector is warming up, Judge, I will tell the court that the animation, as I told the court previously, was prepared by Trooper Austin. This animation, there's 2 of them. The first is the scene model, that is, a view of the Avery salvage property, and what the state believes are important landmarks and items of evidence. It also includes a skeletal animation for which Mr. Strang expressed at least less objection, but something that he may talk about. The animation that I'm going to be showing the court here contains, it's a composite, if you will, of 4,000 or so individual images, all computer generated, but put together to create the animation. And Mr. Austin will eventually talk about that. This animation is a 15 frames per second animation. The final version would be, I believe it's 30 frames per second, but would most likely look very much the same. So the record should reflect then that I'm showing the court something called a scene overview animation, which again is the composite of the computer generated animations. Is there any way to turn down the lights at all, or would you like not to do that? As we watch this, Judge, if I may, Trooper Austin indicates the 15 frames per second rather than the 30 frames per second will have the most impact on things like the gravel road. It won't be as sparkly. It will be smoother, a smoother version. Trooper Austin also indicated any of the text that he's placed into this animation can obviously be deleted, should that be necessary. And as I mentioned to the court, this was brought in lieu of any jury view or scenes. Watching the animation, Attorney Kratz. The record should then reflect, Your Honor, that the scene overview has concluded. The court has been instructed that the anthropologist in this case will be testifying as to some cranial defects, which she and the pathologist described to the jury as entrance wounds. The location of those will be obviously of interest from this animation that I'm showing, although created by Mr. Austin, was under the immediate direction of anthropologist Leslie Lysenberg. It's about 30 seconds long, Judge, And again, the theory of its admissibility and underlying modeling technique will be described for the court, as mentioned, before beginning this part of our presentation. I will be providing the court with copies therefrom, as well as additional testimony from Mr. Austin at the time of the submission of these trial exhibits. With that, Judge, the state is happy to move on to our next matter on the agenda, the court. Mr. Strang, is there anything you wanted to add before we move on? Attorney Strang. Only that I note two things for the court's consideration. One, as to neither of these, apparently, do we still have the final version, the version the state proposes to use at trial. And two, as to the cranial defects, animation at least, this would also be true of the other skeletal representations when one reads Trooper Austin's report closely. These are, in fact, reports of Leslie Leisenberg, and they are well past untimely under the court's October 19, 2006 scheduling order for disclosure of expert witness reports. The court. All right, anything else on that today? Attorney Kratz. Not for today. Thank you, Judge. The court. Next, we'll move on then to the defendant's motion to preclude expert witness testimony and compel disclosure of potentially exculpatory evidence. Mr. Buting, is that yours? Attorney Buting. Yes, Judge. Did the court get a copy of that one? The court. I do. Attorney Buting. Unfortunately, I can't find mine. Did I take it back? The court. You gave it to me earlier, but I think I gave it back to you. Attorney Buting. I have a copy. The court. Well, I take it back. I've got the original here. I don't know if this is the one that's supposed to go to the clerk of courts. Do you have one? The clerk. No. Attorney Buting. Judge, I have attached two exhibits to it. The state has complained that defense wasn't specific enough with their reports, and I attached these two reports to show you, at least with regard to these two FBI reports. These are incredibly sketchy. There's two different ones. The first one, Exhibit 1, is very recent, dated January 12th. Actually, we just received it, I believe, on the 29th of January. Again, way past the expert witness disclosure deadline, so 2 days ago we get this report. And it talks about 3 different shipments of specimens received. Are you on Exhibit 1? The court. Yes. Attorney Buting. November 8th, 14th, and December 27th. It labels them as gives them 2 identification numbers, but there's nothing to tell us what they are other than bone fragments. There's bone fragments. There's 1, 2, 3, 4, and then 31 in another shipment. They identify these as Q11, Q12, and so on up to Q45. But these reports tell us nothing about what they are, where they came from, whether they came from the burn pit, whether they came from one or more burn barrels, whether they came from a completely different location, a quarry, or what, or whether even they are human. So this report tells us nothing, really, other than to say that we can't do any mitochondrial DNA from it. So that's the first concern. Second concern is, the very last paragraph says, if you turn to that second page, it says that the processed DNA generated from these samples is being returned to the crime lab. Well, if they process these items for DNA, they must have some results, and these results are not being turned over. So we don't know whether we don't know whether they're exculpatory or not at this point. But obviously some testing was done. If it wasn't mitochondrial, what was it? And where are those results? Okay? The court. Okay? Attorney Buting. All right. So those are the 2 concerns with regard to that particular one. And I also noted that attached as Exhibit 2 is actually the earlier report from this particular DNA unit of the FBI. And you'll see that it lists item Q1 as charred remains. But that's it. That's all we received from this unit. So there's a gap missing between items Q2 and Q10. Apparently, another 9 items have been tested by the FBI, this unit, and we have never received any results. Are they exculpatory? Are they inconclusive? We don't know, except it's obvious that they're done and those reports weren't turned over along with the other reports of the experts. So if this expert is going to testify then, obviously, we would need to know the results of all of his tests, not just selected ones. So again, if they have done tests on the 35, whatever it is, bone fragments, most recently, and gotten something that's not exculpatory, then that's not inculpatory, then it is exculpatory by definition to us. Same thing here. If those items Q2 through Q10 were tested and nothing inculpatory was found, again, in this case, by definition, they are exculpatory and should have been turned over. And then finally, on that particular report, Exhibit 2, the only finding that's given is that Teresa Halbach cannot be excluded. This is on the second page. Cannot be excluded as the source of the Q1 charred remains. But then it goes on and it lists some database, but there's no opinion provided about what that database is, what the relevance is, whether it matters. There's no further opinions or conclusions or findings drawn from that. So again, both of these reports are very cryptic, far more cryptic than anything we have turned over that the court found was not sufficient compliance with the statutory obligation of turning over findings, summary of testimony, and whatnot of experts. So for that reason, these should either be excluded or the state should file amended ones that do satisfy the statute, and further, they should turn over immediately the potential exculpatory results. Thank you. The court. All right, Mr. Fallon, are you? Attorney Fallon, thank you. The court handling this? Attorney Fallon, yes. Well, once again, I'm here arguing to the court that just because counsel chooses to label something exculpatory doesn't make it so. I wish the world were as simple as counsel would suggest, that if it's not inculpatory, it must be exculpatory, or vice versa. With respect to the reports, let's take Exhibit number 1 first. Exhibit number 1 I find rather interesting because it is a report prepared by FBI analyst Douglas Hares, I'm taking them in reverse order. Exhibit number 2, a report by Douglas Hares. The report is dated January 17, 2006. And only now is there apparently a question regarding the sufficiency of that report. In answer to that, I would offer this information to the court. The counsel is certainly aware of it. Quite some time ago, the entire protocol of the FBI with respect to this analysis was provided to the defense. A CD with the data generated during the course of the analysis has been provided, much like the genotype and genoscan information which was turned over pursuant to the Wisconsin Crime Laboratory's DNA analytical procedures and protocols and data generated. Finally, we have the report itself of Mr. Hares. And I think, simply answered, it is what it is, that Teresa Halbach cannot be excluded. It uses the counting method, which is pretty much accepted in all laboratories. And it's rather interesting to hear a concern about the counting method, which is usually offered by the defense as a means to supposedly undermine, for whatever reason in their minds, the significance of the results or the findings there. The report has been provided. All of the underlying data has been provided. And the opinions that will be rendered by Mr. Hares are contained in the exhibit. That's it. There, as I say, there ain't no more. It is what it is. Those are the only opinions, if in fact we even have an opinion, offered by Mr. Hares with respect to the statistical counting. The court. Let me stop you there. There's a sentence in Mr. Buting's brief on page 4 that says, Mr. Avery, this moves the court to prevent any testimony from the DNA analyst and Exhibit 2, Douglas Hare's, other than his opinion that Teresa Halbach cannot be excluded as a source of the charred remains. I take it that at least to the extent Mr. Harris would testify about this report, you are telling me that's exactly right? Attorney Fallon, his report is what it is. The court, okay. Attorney Buting, and that's all. That's the only opinion that would be rendered from this report? See, that's what's not clear. If that's all this Douglas Harris is going to say, fine. Attorney Fallon, in my discussions with co-counsel, Mr. Gahn, that's my understanding. I mean, if that would somehow change in the next 24 hours, I would be happy to let the court and counsel know. But as Mr. Gahn advised me, the opinions expressed in the report are the opinions which are going to be offered. The court. All right. Attorney Fallon. And as I said, they have all the data. And here it is, a year and 2 weeks after the report was generated, and it's probably 10 months since provided in discovery. With respect to the other exhibit, this one I can speak to with even greater detail and surety. I have had discussions with the analyst here, Mr. Les McCurdy, and I guess I would preface my remarks here by indicating that Mr. McCurdy's findings are already reflected in Dr. Leslie Leisenberg's report, which has been provided to the defense. For whatever reason, the FBI was late in providing their written report of the oral findings that they already provided to Dr. Leisenberg. But nonetheless, I did ask Mr. McCurdy about the language that counsel finds so troubling. And I learned that the last paragraph, which begins on page 2, the submitted items will be returned under separate cover, etc., is language that is apparently standard language in all FBI reports, regardless of whether DNA is generated or not. I would direct the court's attention to the preceding paragraph. It says, due to the condition of the submitted bone fragments, no mitochondrial DNA examinations were conducted. I verified that with Mr. McCurdy on the phone, both yesterday and this morning. Knowing that counsel has had problems and has been doubtful of representations that the state made in the past, I asked him, would you provide an amended report further explaining that no DNA extractions were occurred? And he did, in fact, provide us with an amended report taking care of that, and I provided 2 copies to the defense. No DNA was extracted from those bones because it wasn't possible. Their condition had deteriorated as a result of the fire to such a degree that DNA could not be extracted. And finally, I'm troubled by, again, the insinuation and representations that we must be hiding things. So, for counsel's benefit, because we don't have to do this, but in the interest of providing the information and getting this trial going, I will offer this information to counsel. The FBI uses the letter Q, capital Q, designation for items submitted, and we have items 1 through 45. Items 1 and 2 were Calumet Sheriff's tag numbers 7926 and 7927. Q3, which counsel finds mysterious, and I would only suggest that he review previous discovery, was the Sure Shot camera. Q designation 4 through 10 were the cell phone parts. Q11 and 12 was item number 9597, cranial pieces from the burn pit behind the defendant's garage. And I believe, and I'm not sure of the circumstances, but it was originally tagged 8318. Attorney Buting. Which one was that? I'm sorry? Attorney Fallon. Q11 and 12. Q13 through 38 were items in 7964 from Burn Barrel 2. Items Q39 through 45 were designated items 8675. And we believe that's referred to in many places in the discovery as the redundant debris pile. So I think that clears up the information, which is all has been provided and examined and discussed at length. So I'm at a loss, quite frankly, to explain further the purpose of this motion. I think we have resolved, to all satisfaction, what the circumstances here. So without any further comment, I will rest. Attorney Buting. Judge, one last matter is still not clear. On page 3 of my motion, I point out it is not clear whether any of these items that were sent to the FBI have been determined to be human or not, because there's many non-human bones that were in those barrels, pits, and everything else. But I don't know if counsel knows that, but this report, one of my concerns is the report doesn't say that. We don't know whether these are human or not human. In fact, until he told me today that these were. The report wouldn't tell you that. So there's still an additional concern. The court. You are referencing now to the Attorney Buting, Exhibit 1, that has items Q11 through Q45. The court. Mr. Fallon, is that information provided anywhere in submittals? Attorney Fallon. Can't be identified. That's the whole idea. There was an attempt at mitochondrial DNA, or any DNA for that matter. They are still suspected possible. The court. Q11, 12, 13, 14, through Q14.8 and Q15 through 45. None of those were able to be identified? Attorney Fallon. That wasn't the question counsel asked. Counsel asked on items, I believe, 13 through 45. I believe the other items have been identified. The court. Okay. Attorney Buting. Well, the simple question is Q11 and Q12. If those have been identified as the cranial, is that what you're saying? Attorney Fallon. Those are cranial pieces. Attorney Buting. Okay, so those have been identified as human. But as to the others, for instance, Q39 through 45, labeled as redundant debris pile, simple question is, were those human or were they not? Attorney Fallon. You know what we know? You know what we know. Attorney Buting. Well, what opinion will be expressed by an expert? Attorney Fallon. Well, the opinions are set forth in the laboratory reports from the FBI analysts that mitochondrial DNA was not possible to determine that. And Dr. Leisenberg has already indicated in her reports, suspected or possible, and the question is that even admissible? But that's for another day. Attorney Buting. That's fine. So these experts will not render any opinion on that. Is that right? Attorney Fallon. As I understand it, I'm confirming that with Dr. Leisenberg. The court. There was a reference on page 5 of Mr. Buting's brief to other experts for whom he indicates the defense has not received reports. Carl Adrian, Eric Smith, and Robin Cotton are those, as I understand it, those are witnesses that the state named, but no reports were provided? Attorney Buting. Correct. Judge, the Carl Adrian one, I believe, he is the one who did a similar kind of recreate laser measurements of the RAV4, if I stand corrected. Am I right, counsel? Attorney Fallon. Yes. Attorney Buting. As to that, we have still not seen any reports. Eric Smith, I'm not sure who he is, what his report is. Robin Cotton, I know who she is, and I have definitely not received any report from her. She's in Boston, a former DNA expert at Cellmark. So if they're intending to put in another DNA expert, there have been 0 reports from her. The court. Mr. Fallon. Attorney Fallon. With respect to Robin Cotton, I guess counsel should consider himself fortunate that he has one potential rebuttal witness. Mr. Gahn has not advised me as to whether or not she will be appearing and or whether she's ever even written a report relative to this particular case. The court. And Mr. Adrian and Mr. Smith? Attorney Fallon. Mr. Adrian is, as represented, he's an analyst who put together a computer-generated animation of the SUV. I will let Mr. Kratz speak to that. He's more familiar with Mr. Adrian. Attorney Kratz. I'm sorry, Judge. Mr. Adrian, the court has already received the SUV animation in participation of that. Defense counsel received a disc of all the measurements that were created from Mr. Adrian's work product. There is no report other than the item itself, that is, the computer animation itself. Attorney Fallon. I would have to check. That was the one thing that I ran out of time trying to run down. But I believe the last gentleman may very well be simply one of the many agents from the FBI who may have had a hand in the chain of evidence. Counsel has reminded me that Mr. Smith is the tool mark analyst at the FBI. We're not planning on calling him. Attorney Buting. Are not? Attorney Fallon. Are not. Attorney Buting. Well, as to Mr. Adrian then, if he has no report, and I guess the summary of his testimony would be the animation that is being offered to as a substitute, certainly. There is nothing like that for Robin Cotton. So we're way past the deadline, and I would move the court to exclude any testimony from Robin Cotton. The court. I understood the state to be saying they would not be offering any testimony from her in their case in chief. Attorney Fallon. That's my understanding. The court. I also understand the state to be reserving the right to introduce her in rebuttal under Conkle. Attorney Fallon. Correct. Attorney Buting. So she will not be allowed to testify in the state's case in chief. The court. In the case in chief? Right. Mr. Buting, does that address your concerns that you have raised in that motion? Attorney Buting. I believe so. The court. I'm not sure if you require an order, but if you wish an order to reduce to writing the indications that the state made, you may do so and submit it to Mr. Fallon for this approval, and you can submit it to the court for signature. All right. The next item is from the defendant's motion to dismiss of last week. The court addressed the 3 counts. The state moved to dismiss 2 of them. The court denied the defense motion to dismiss the 3rd. But, Mr. Strang, I believe there was another portion of that motion which you wish to bring up again. Attorney Strang. Right. This is an issue that I have raised in several different forms or settings since the spring of 2006. And at its core, or germ, are the March 1st and March 2nd, 2006 news conferences that the state conducted, laying out on March 1st the purported statements of, at that point, an unnamed relative of Stephen Avery in a live televised news conference format. The court has the DVD of that news conference and I think has viewed it. And then the following day, March 2, and this is the news conference that was preceded by the warning of its graphic content and urging that young people under a certain age and friends of relatives of Ms. Halbach not watch because of the graphic content. And in that news conference, the state identified Brendan Dassey and gave a very gripping narrative, chilling and horrifying narrative of what the state imagined to have occurred at the Avery property, based on what was then Brendan Dassey's purported version of events. The March 10 amended information followed directly from Mr. Dassey's version at the time, and the version laid out on March 1 and March 2, 2006. Mr. Dassey himself disavowed that version in large part not later than May 13, 2006. The physical evidence disproved most of the gory details, and the state presented on March 1 and March 2 in particular. But in the public mind, we have had 10 months of seepage of those details. 10 months of the public believing that Stephen Avery is an alleged rapist in this case and alleged to have kidnapped Teresa Halbach in addition to murdering her. And the fruit that 10 months and that those 2 press conferences have borne is there for all to see in the 144, something fewer than that, jury questionnaires, where time and again jurors are telling us that their opinions, many of them unalterable according to the jurors, prospective jurors' reports, are traceable not just to publicity, but many of these prospective jurors cite in particular Brendan Dassey's supposed confession and the power of it, although inadmissible, the power of it in the lay mind as to Mr. Avery. The questionnaires are of course, a part of the court record. Court, I assume, has reviewed those, as have I. At least one prospective juror specifically cites Mr. Kratz's statements about Brendan Dassey's confession as the source of her opinions. And I don't remember now what language the juror used in response to question 43, or question 69, question 74, and just how unalterable that opinion was. But that, again, is now a matter in the court's record that could be reviewed if necessary. There may have been more than one juror. I read these questionnaires very quickly because of all the work that all of us have confronted this week as we prepare for trial on Monday. The presumption of innocence has been lost here, and it happened that dissipation happened, I think, March 1st, March 2nd, or as a result of those comments. And now, 10 months later, of course, Mr. Avery is not facing a rape charge at all, not facing a kidnapping charge. The state has elected to go forward on a false imprisonment charge that I think cannot make it to a jury, unless there's evidence that the state has, of which I'm unaware through the discovery process, and I oppose that problem in my motion to dismiss the false imprisonment count and the other 2 counts. And I've expressed it here in court, the risk we will run if the state, in fact, has insufficient evidence of false imprisonment here in the context of the highly inflammatory, highly prejudicial news conferences together running on March 1st and March 2nd alone, setting aside the other 6 televised news conferences, just those 2 running together, running to 56 minutes or more, followed by the 10 months of the drumbeat in the media on this case, reiterating the state's allegations. So, dismissing those 2 counts isn't enough. Dismissing the 3rd false imprisonment count isn't enough here to restore the presumption of innocence to which Mr. Avery constitutionally is entitled. The court needs to do something more, and the jury questionnaires that we have now reviewed bear that out. I will make a further record, I'm sure, on Monday, in moving to strike for cause a number of additional prospective jurors, people who filled out jury questionnaires on which the state and the defense did not agree that there was cause to strike. I will move to strike a number of additional jurors as having unalterable opinions and, therefore, not being fit for service as a juror in this case. But I would like to see this court take some firm action to try to save at least 30 members of this panel, if they can be saved as appropriate, open-minded, potential jurors who are willing to follow the court's instructions and, indeed, the constitutional rules of criminal procedure in this country. The court is going to have to do something to restore that presumption of innocence. I suggested a curative instruction. I laid it out. There is no particular magic to my language, but it would have to be a strong instruction, and more than once repeated, just as the message about Brendan Dassey's accusation against Stephen Avery has been more than once repeated, and the message about the first-degree sexual assault charge and the kidnapping charge have been more than once repeated. The court faces, I realize the court can't give a counteracting instruction as many times or as powerfully as the initial message was heard, but the court has got to try here to erase that prejudicial effect of the last 10 months, now confirmed in its unfairness by the fact that the state did not commit to calling Brendan Dassey by the deadline that we had agreed and the court had set, may not and is not going forward on 2 of the charges that are brought on March 10, 2006. Lest there be any question at all about the power of those accusations, now dismissed, and at their time resting only on the inadmissible claims of Brendan Dassey, lest there be any question about the power of those at all, this court, an experienced judge, a skilled lawyer for many years before that, this court was moved by those allegations to say that $500,000 bail for this man is not enough, and that there is a stronger case against him now, greater incentive to flee or to fear conviction, and increase the bail, as I recall, by $250,000 to $750,000, citing the new charges in the amended information that at the time, I believe, rested only on the inadmissible claims of Brendan Dassey. And the time now has confirmed the state cannot corroborate and cannot advance to a jury, even in their opening statement, unless it commits to call Brendan Dassey. And that's why at least 2 of those counts have been dismissed. When those kinds of accusations and those new charges move a court to raise by 50% an accused bail, I have a pretty good sense of what they do in the lay mind among this jury pool in terms of persuading that jury pool that the case looks much stronger against Mr. Dassey than, in fact, it turned out to be. And that's what we're up against. An action and I'm asking this court to take strong curative action, whether it's my instruction or one of the court's own writing or some other curative step designed to restore to Mr. Avery the presumption of innocence that due process and a fair trial require. The court. Who will be addressing this matter for the state? Attorney Kratz. I will, Judge. The court. Mr. Kratz? Attorney Kratz. I am quite certain that Mr. Strang does not want to enter into a debate at this time as to the relative strength of the state's case. I would argue with Mr. Strang in his conclusion that the state does not have a strong case now, as it did on March 1st. Obviously, the state believes it has a much stronger case now than it did on March 1st, given the physical evidence that's been detailed. And we have become familiar with that notwithstanding, Judge, that the jurors who have been unable, for whatever reason, to presume Mr. Avery innocent, or the jurors who have indicated to this court an unwillingness to follow instructions, have already been stricken. We'll be making a record of that on Monday. But as far as the risk of jurors who cannot follow instructions or who have some preconceived notion, that's already taken into account in the jury process. And that's not unique to the Avery case. That's a process that this court engages in each and every time we try to pick a fair and impartial jury. Mr. Strang's suggestion of some curative instruction necessarily requires this court to place some blame upon the state. That is, that there was some unfair publicity in this case. I will remind the court that that very motion was brought by Mr. Strang many, many months ago. This court made specific findings that the state did not engage in any behavior that violated Supreme Court Rule 23.6, that the state through its comments that this court, I believe, made findings, included invited response and other reasons for those comments, did not preclude and do not preclude the defendant of a fair trial. And so, to suggest at this point that even after making those findings months and months ago, that the defense is now somehow entitled to some damning instruction, some instruction that suggests that the state's behavior or the state's comments in this case were improper, is just not warranted. This court has cautioned counsel, that is, counsel for the state and counsel for the defense, as to extrajudicial comments. And to my knowledge, one party has abided by that. That is the state. That since March 2nd, no extrajudicial statements of any significance have been made in this case. I can't say that for Mr. Buting or for the defense, but the state has certainly abided by this court's admonition. Let me also suggest, Judge, that to engage or to go down this road of curative instructions would necessitate the court explaining the nuance of use immunity and the reasons why a prosecutor may decide what charges to go forward with or what charges to not go forward with. Mr. Dassey's inconsistent statements, again, are hardly unique to a criminal defendant like Mr. Dassey, but certainly are not of the substance that some curative instruction is made of. Let me close, Judge, in saying that, as I argued earlier this week, the state could have proceeded on the rape and kidnapping charges. The fact that we have chosen not to, the fact that we have chosen to either save Mr. Dassey for, if not case in chief, a rebuttal witness, and the conference of use immunity is solely within the province of the state, not something that the court or the defense has any say-so in. And with that having been said, any curative instruction is improper, would prejudice the state, would ask the court reject that possibility. Thank you, Judge. The court. Anything else, Mr. Strang? Attorney Strang. Well, the notion that the state ending its extrajudicial comments after March 2nd solves the problem is a little bit like the away team in a baseball game saying, well, I had my at-bats in the top of the first. I hit a home run, and now the remedy is not to allow the home team to come to the plate in the bottom of the first and not to play the rest of the innings. We, in fact, haven't given a single news conference or called people to our office or set up a bank of microphones or given a warning graphic about content, let alone given 8 news conferences. And functionally, we've been able to reclaim the presumption of innocence. We have been unable to reclaim the presumption of innocence here. And the court need only look at the jury questionnaires we have to see just exactly which side here has had its impact on public opinion before this case gets tried. The court. All right. The parties will have an opportunity in individual voir dire to further explore what opinions the jurors have, what they may have seen or heard, what they come into this case with. The court will listen to the comments of the jurors during voir dire. And if I feel a need to address anything in the form of an instruction to the jury, the court generally, at the start of the trial, gives the jurors some preliminary instructions, including information on the substantive charges. And I will make my ruling on the motion explicitly or implicitly at that time with the instructions to the jurors. The next item is a motion from the defense regarding courtroom security. Mr. Strang? Attorney Strang. I think we were also going to address the second motion in limine. The court. Oh, I'm sorry, you're right. I passed over that one. That was the next one. Attorney Strang. But that turns out, I think, to be fairly easy. After some conversations with Mr. Kratz, I'm satisfied that I now can reconstruct the information I was seeking as to the first part of that motion in limine, and as the second part concerning some converted telephone calls, I will simply make a record of what I think we discussed in chambers, or my recollection of what we discussed in chambers is that the state is working on some conversions. I know what it means by conversion now. When it has done those, it will offer to the defense the opportunity to see the closed captioning, so to speak, for the real-time transcription that it proposes to offer as to some recordings. We'll have a chance, I assume, to assure ourselves that the recordings themselves were not altered or redacted in a way that would make them less than complete, and that the transcription is accurate. And I also understand from our discussion in chambers that I should not expect any objection from the state or any resistance from the court to giving an appropriate jury instruction on transcripts being aids to understanding evidence, but not evidence in themselves, that the recordings themselves are the evidence. So, if I understood our conversation about part 2 of my second motion in limine correctly, then at this point the court simply can hold the issue in abeyance. The court: all right, maybe I missed it. The star 67 issue. Do I understand? Attorney Strang: that's part 1, and I think we're squared away on that. The court: okay, all right. At this time, the court will move on then to the defendant's motion concerning courtroom security. Mr. Strang? Attorney Strang: yes, Your Honor. The state hasn't responded, but I have been provided by the court, and I think counsel for this state have as well, the January 28, 2000 letter from Sheriff Jerry Pagel of Calumet County. And I guess the inference I draw from Sheriff Pagel's letter is that he believes that security measures at trial ought include what I have called a stun belt. I guess Sheriff Pagel uses the same term in his letter. So, as I understand it here, it falls to the court to decide whether there's manifest necessity for such a security measure. And the case law is pretty thin in Wisconsin, although there is some, not on this particular restraint. There's a good deal of case law both in other states and in federal courts around the country. And I have provided the court a smattering of it. I couldn't possibly provide all of it. I have relied on particular here on the neighboring state of Illinois, both because of the recency of the Illinois Supreme Court's decision on this type of restraint, and because its detail and usefulness of the factors it suggests trial courts take into consideration. But the burden either rests on the court or on the state to justify such a restraint as necessary and consistent with the defendant's 6th and 14th Amendment rights to a fair trial, the assistance of counsel, confrontation, and to testify in his own defense, if he chooses. The burden, I'm sure, does not rest on the defense here, and that's between the court and the state. I'm not sure exactly where it does rest, but there would have to be an evidentiary providing, I think, and some findings by the court on necessity if the court is considering deferring to Sheriff Pagel's apparent wishes. The court: anything further, Mr. Strang? Attorney Strang: not at the moment, I guess. The court: okay, this, as Mr. Strang indicated, this issue is not necessarily a prosecution versus defense type motion. It's a matter for the court to determine based on considerations for courtroom security. But does the state wish to be heard? Attorney Kratz: yes, very briefly, Judge. The state echoes the court's feelings that this is not a prosecution issue. I do have a personal opinion as the person who would be seated 5 feet from Mr. Avery during this trial as to whether some security is necessary. But from the prosecution standpoint, the only comment we have as to Mr. Strang's suggestion that this raises to a due process right is how does the defendant wearing a stun belt affect affect his ability to participate? How does it affect his ability to speak with his attorney or in any other way to participate in the proceedings? This is a security issue. I don't tell the sheriff how to run his jail or how to do courtroom security, and we have got a deal that he doesn't tell me how to run my office, at least not very often. So, with that having been said, Judge, we'll leave it to the court and to the Sheriff Pagel as to a decision on the courtroom security issues. Thank you. The court. All right. I have the letter from Sheriff Pagel in front of me. I'm not sure, Mr. Strang, if the defense is in agreement with the court making its decision based on the reasons given by Sheriff Pagel for his request, or whether you wish to question Sheriff Pagel. Attorney Strang. I am not in agreement with that, because at a minimum, some of these issues would need elaboration. The letter is a helpful starting point, and indeed, in my motion I have conceded that these are serious crimes. There's no gainsaying that. It is the most serious crime with which one can be charged in the state of Wisconsin. So that factor weighs in favor of restraint, standing by itself. Some of these others, as I say, at a minimum, would need evidentiary development. The court. Do you wish to question Sheriff Pagel? Attorney Strang. Yes, by doing so, I'm not taking on a burden, I gather. The court. No, you are providing information to the court to assist the court in making its decision. Attorney Strang. Very well, I'm happy to do that. The court. All right, Sheriff Pagel? Sheriff Gerald Pagel, called as a witness herein, having been first duly sworn, was examined and testified as follows. The clerk. Please be seated. Please state your name and spell your last name for the record. Gerald Pagel, P-A-G-E-L. Direct examination by Attorney Strang. Just as a matter of background here, we all know the answers to the questions I'm going to ask preliminarily, but someone else reading the transcript later may not. Quickly, you have been the Calumet County Sheriff for some time, and at all times since November 5th of 2005 through today? That is correct. You are responsible both practically and statutorily for administration of the Calumet County Jail? That's correct. Mr. Avery has been detained in the Calumet County Jail since November 9th, 2005? That is correct. Continuously? Yes. So you have been his keeper, in effect, here as a pretrial detainee? Yes. He hasn't been serving any sentence or on any probation or parole hold during that time, to your knowledge? That is correct. You have overall operational responsibility for the Calumet County Jail? Yes. But as a practical matter, you get information from officers whose immediate job responsibilities are the jail and the jail only? That would be correct. And the person you might describe as most directly or most immediately in charge of the jail over in Chilton is it Captain or Lieutenant Burns? Lieutenant Burns. Am I right about his direct responsibility? That would be correct. Okay. And then there's Sergeant Hemauer, who reports to Lieutenant Burns? That is correct. Who has also got a good deal of direct responsibility for the jail? Yes. Does most of your information come through either Lieutenant Burns or Sergeant Hemauer? Would come from Lieutenant Burns as well as other individuals working within the jail. Okay. This, as I understand the rules of evidence, Sheriff Pagel, and for the court's benefit, I think this is one of the proceedings to which the rules of evidence don't apply. So what I'm telling you is that I'm going to ask you for hearsay. I'm going to accept hearsay. We don't have a problem with hearsay here as long as it's reliable. It would be helpful if you could tell me when you know something personally and when you are relying on word from Lieutenant Burns or someone else. That will be done, yes. Okay. Did you have the good sense to bring your January 28 letter with you? Yes, I did. All right. We should probably mark that as an exhibit. Is that an extra copy? Yes, it's not signed, but it's a copy. That's fine. Exhibit 1, marked for identification. All right, and we have marked this as Exhibit 1. It is now stapled. But is that your January 28, 2007 letter to Judge Willis? Yes, it is. I understand that's an unsigned copy, but the substance of the letter is what you wrote? That is correct. Let's go to paragraph 1, if you would. To whom has Mr. Avery made the statements that you ascribed to him in paragraph 1? Those were statements that were heard being discussed in phone conversations that Mr. Avery had and was relayed to me by investigators working this case. Do you remember when those statements were made? No, I don't know when they were made. Do you remember how many times Mr. Avery made such statements? No, I would have to defer that to the investigators. Mark Wiegert or Tom Fassbender? That would be correct. Okay. And did you have it set out here, the verbatim statements that you are describing being told about, have you? No, this was information that was provided to me by the investigators who indicated that they heard these conversations or heard words mentioned by Mr. Avery during these conversations. To this effect? Yes. Okay. Do you remember about when one or the other of these investigators told you about these conversations? They had mentioned it to me prior. However, when I was informed that there had been a motion filed, I specifically went and spoke with them, and they, again, furnished me with the information that is contained within this letter. Okay. When you say they told you about it prior, can you give me a time frame? How? No, I cannot. It was just generally spoken to me, and comments were made to ensure that I was made aware of these comments, to ensure again that action or specific information would be provided to the staff running the jail, to ensure their safety, and to ensure that he, meaning Mr. Avery, would not do anything to try to jeopardize their safety or to escape from jail. Can you put a year on when you first heard about this? I would imagine it would have been last year. 2006? Yes. Okay. Early in the year? Late in the year? I can't tell you. I don't know. Did you take any specific action in the jail? I know that the jail staff was informed. Lieutenant Burns was informed, just to be made aware of. All right. And one way to take these is that Mr. Avery might harm himself, correct? Could be, yeah. They could be taken that way. And in fact, you're aware that Lieutenant Burns has gently inquired of Mr. Avery on a number of occasions whether he is inclined to harm himself? Yes, that's correct. And you have been assured that he is not inclined to harm himself? That is why I have been informed by Mr. Burns. Okay, indeed. Other than one brief period in which I know Mr. Avery has not been confined in a segregation cell, or a cell you can watch someone 24 hours a day, correct? He's been in a regular pod or cell? Yeah, he's been in his cell block. Okay. As to comments that he needs to get out of here, is that kind of thing all that uncommon for people who are locked in a jail? Well, you have to look at the seriousness of them, and you have to take them as a general comment, but you have to be also concerned about those types of comments. Sure, and I understand that. And when you think someone really may be planning a jailbreak, an escape, there are some measures you can take, correct, within the jail? Yes, there would be. You could cut off all visitation, correct? Yes. You have never done that with Mr. Avery? No. You could frisk contact visitors, defense lawyers, or probation agents, police officers for that matter, just to make sure that they're not passing anything physically to Mr. Avery, correct? That would be. You have never seen a need to do that? No. You could put someone in segregation if you suspect an escape attempt? You could, but it might not always be the best thing to do for that type of situation either. Okay. Have you had an experience as sheriff when you were aware of an actual escape attempt by any inmate of the jail, convicted or pretrial, anybody at all, prior to discovery of something? Is that what you are referring to? Right. Not that I'm aware of. Awareness of a plan to try to escape? No, I can't say that since I've been sheriff. No. Do you have contingency plans for that if it were to happen? There would be some plan put in place, yes. Okay, but no such plan has been implemented as to Mr. Avery at any time? No, there is not. As a routine matter, in the jail, even though he is not convicted of anything, administratively you folks, I don't want to say regularly, as if it's a fixed cycle, but with some frequency, jailers come in and examine the entire cell without the inmate in it. Yes, they would do searches. And that's been done in Mr. Avery's case, correct? I would hope so. Okay. Do you know so, or? It's a general practice for them to do that, and I would assume that they have done that, yes. Right. You have no reason to think that the habit of occasional cell checks hasn't been followed with Mr. Avery. That's correct. Has anybody told you that they, found a cake with a nail file in it, or, bed sheets tied together, anything that suggested an escape? No, I've not been told. And I don't mean to be cute about that, but whatever it is that inmates might do suggesting an escape, that has not been given to me, no. That has not been provided to me. Attorney and witness talking over each other. Question. Nothing's been found in Mr. Avery's cell? Nope. I'm not aware of anything like that. Yes. Any homemade weapons been found in his cell at any time? No. Something that might be used to hurt a guard? Nothing was found. Okay. While he was in our custody. All right. Has he acted out violently at any time while he's been in your jail? Not that I'm aware of. I've not been told that he has. You think you probably would have been told if it had happened? Yes. So he hasn't. He hasn't been segregated for behavior problems at any time. No, he has not. He has been kept alone, if you will, or without cellmates or even podmates for most of the time there, correct? Per your request, yes. And that's where I'm going. Part of that was driven by my request, correct? That is correct. And you've been kind enough to honor that with a proviso that if you got real full, you might have to move people in, correct? That is correct. That was the agreement. Okay, so that wasn't a measure that was implemented because you were afraid Mr. Avery might hurt a fellow inmate. No. You did have some concern, as I recall, at some point, that because of his notoriety and the publicity attending his case, that another, not a specific inmate, but some other inmate conceivably might try to take a poke at him or hurt him at some point. That would be a correct statement, yes. Okay. Stephen Avery is 5'6". I would say 5'5", 5'6", yes. And he's put on a little weight, I think. Sorry about that, but I don't know, 200 pounds or something roughly, probably. Yeah, I would say so. Okay. He doesn't have access to free weights or exercise equipment in the jail, does he? No, he does not. Could we go to paragraph 2 in your letter? Sure. You refer to several individuals who have been interviewed. Are you relying here again on information from Mr. Wiegert or Mr. Fassbender or other investigators? That would be correct. Do you have any? I guess the specifics are that these were all things included in Mr. Kratz's other acts motion? Part of it, yes. Part of his motion. Okay, so the court already has before it some more details about the information you are describing in general in paragraph 2? That would be correct. Okay, paragraph 3 in general. You are saying, look, we've got information that witnesses are concerned about testifying and have indicated that they are fearful. Answer, yes, this has been given, again, to the lead investigators. that they are fearful, concerned for their safety, having to testify against Mr. Avery in court. Okay, and what have you done and what you have done is reassure those people that their safety is an important consideration to you. Yes, that was done by, again, the lead investigators when they spoke with them, that their safety would be of utmost concern. Sure, and this was not the first time that you or people in your department have had citizens or potential witnesses express concern about testifying in a criminal case. That would be a correct statement, yes. In fact, it's not uncommon for that sort of concern to be raised with you. That would be true, yes. This is in the general nature of that experience of yours as an officer. Well, these individuals have expressed a sincere concern to have to testify. It's not like, well, I don't want to, or I wish I didn't have to. They are concerned. They have expressed their concern to be in court and have to testify and to be in the same courtroom with him. So they have expressed a deep concern for their safety. Are these people who you know or have been told have an aversion or a revulsion for Mr. Avery, just as sort of a global matter? They just don't like him? I don't know if it's that or the fact that they know of his demeanor. I don't know how far you want me to go with that, but they, again, it's a concern that they have expressed, and that's why I place that in the letter. Sure, and some of them may know him or have had some past experience with him? Yes. Okay, and you're not aware of any threat that he's made to any witnesses or potential witness? Not that I'm aware of, no. Every non-contact visit with Mr. Avery has in the Calumet County Jail is tape recorded. Every non-contact visit. Yes, as it is with other inmates. With everybody else? Yes. Right. This isn't a special measure for Mr. Avery. No, it is not. Every telephone call that he makes out of the jail is recorded, just as every telephone call that every inmate in the jail is recorded. That is correct. In this case, if there's any difference at all, the investigators on the case assiduously listen to Mr. Avery's tapes, correct? That's correct. So you would expect that if he had made threats to specific witnesses, those would have been reported to you in your capacity as sheriff. It probably would have been. I would have been informed of them, yes. Paragraph 4, yes, refers to a specific conversation or conversations, a telephone dialogue between Mr. Avery and his father. That's correct. All right, when did that happen? Again, I can't give you a specific date. I know it was, again, I believe in 2006. But whether it was the beginning of the year, the middle, or the end, you don't know? I would have to refer that to Investigative Wiegert. All right. Do you know the nature of the comments as to Mr. Fassbender and Mr. Wiegert? Yes, I do. What is that? The witness. You want me to elaborate, Your Honor? The court. Yes. The witness. Okay. There was a conversation between Mr. Avery and his father in which they, Special Agent Fassbender and Wiegert, comment was made that they wanted to cut off his testicles or cut off their testicles and drag them behind, or Investigator Wiegert, behind a pickup truck. Just Mr. Wiegert? I believe it was Mr. Wiegert, yes. And was it Alan Avery who made that comment, or Stephen Avery? Excuse me. I believe it was I believe Mr. Alan Avery was making the comment, to which Stephen laughed heartily. Okay, so this was a statement not made by Stephen Avery, but he laughed in response to his father's statement. That's correct. That's the way I've been told. All right, both Mr. Wiegert and Mr. Fassbender are law enforcement agents, obviously. Yeah, that's correct. Both of them would be armed ordinarily. Yes. While on duty? Yes. Are sworn law enforcement officers allowed to carry their sidearm weapons in court in Calumet County, if you know? Yes, they are. Both of these men are in the prime of their life, for want of a better word. Yes. I mean, they're young. I mean, they're in their 30s, 40s, whatever it is they are. Yes. Okay. And they, in fact, were also the two officers who arrested Mr. Avery on November 9, 2005, weren't they? Yes, they would have been involved, I'm sure, in the arrest. It's probably been a while, so I'm going to offer you an exhibit, just to help refresh your recollection. Exhibit number 2, March 4, identification. I have marked this as Exhibit 2, and what it is a DCI report. Looks like Special Agent Fassbender is the author of this one, and it details a meeting with Mr. Avery on November 9, 2005, and his arrest pursuant to an arrest warrant. Okay? Yeah, and then, continues from there. The copy I have given you sort of helpfully has what we call a Bates stamp number on the bottom right corner. Begins state. Okay. And the first page is state 0536. Yes, okay. If you go to state 0546, okay, at the top, what we have is, and I think this is Mr. Fassbender authoring the report, yes? Yeah, the reporting law enforcement officer on the front is Thomas Fassbender. And what he is doing starts at the bottom of the preceding page. He is describing here Investigative Wiegert and himself informing Stephen Avery about 12:47 in the afternoon that they had an arrest warrant for him. Okay. And they are out at Earl Avery's house, which is where they found Stephen Avery that day. And as I read it, what Investigator Wiegert told Stephen that in arresting him, he would not place him in handcuffs if Stephen was cooperative and did not cause any problems. And Stephen advised that he would not cause any problems. Do you see that at the top of page 0546? Okay, yes, I see that, yes. Now, people like me wish that law enforcement officers would show that sort of humanity and judgment more often. But in point of fact, this is unusual to take someone into custody and not handcuff them, isn't it? They're given discretion of whether or not they wish to handcuff individuals. Right, and in your experience, more often than not, that discretion is exercised in favor of handcuffing someone who's just being arrested pursuant to an arrest warrant, correct? Well, again, it's done for several different reasons. If they feel that individual needs to be handcuffed, they will. Right. If they wish to possibly gain that individual's cooperation or gain rapport with that individual, they may not. Sure, and that's where the discretion comes in. That is correct. Or maybe someone is very aged or has bad arthritis or whatever it is. Yes, there's a number of things that would be taken into consideration. Sure, or could be. Someone, an arrestee, might be well known to the officer, and the officer figures he knows this person's character well enough to make that judgment call, correct? Yes, that would be something that they could, but again, the whole situation has to be weighed. Right, and whatever the considerations were, what we know here is that Investigator Wiegert and Mr. Fassbender felt comfortable coming down on the side of not handcuffing Steve Avery when they arrested him on this case. According to this report, yes. Transporting him in a car, correct? Yes. That was a DCI car, right? I don't know. I think it says that. I'm sorry, and it's further down that page, the middle paragraph that says at 12:50 p.m. Okay. So they are driving Mr. Avery off to get his DNA taken? Okay, well, yes, okay, would have been. Would have been Mr. Fassbender's vehicle, yes. You are familiar with that car, aren't you? Yes, I am. It's not a cage car. No, it's not. You haven't heard anything about Mr. Avery taking that opportunity when freshly put under arrest to try to hurt Mr. Wiegert or try to hurt Mr. Fassbender, have you? No, I have not. Do you think you would have heard that? I'm sure I would have. Finally, paragraph 5. I think I've heard about this person, but I want to make sure that I'm thinking of the same one you are. Okay. There's a woman who holds herself out as a pastor or a minister who comes to visit Mr. Avery, correct? And that's correct. All right. And she has a pastoral assistant or an assistant minister, someone with her often, correct? And that's correct. Also a woman? Yeah. Have you met both these women? Yes, I have. These two ministers? Without insulting anyone, are these two women both at least 70 years old if they are a day? That would be elderly, yes. Okay, and I'm not suggesting you know exactly how old they are. That is correct, I do not. Elderly women who are apparently ministers by vocation? Yes, that's what I've been informed. And they also minister to or have played some pastoral role, apparently, with Jody Stokowski? Okay, I'm not aware of. Oh, okay, maybe. Then let me go at it this way. Okay. Was Jody Stokowski the third person in the car on this incident? Yes. All right, so there's these two elderly female ministers and Jody Stokowski in the car? Yes. And as I understand, the car comes up alongside or stops at the same red light or something as a sheriff's department van or car in which Mr. Avery was being taken to court? Yes, in Manitowoc, but they had noticed that this vehicle had been following them from the city of Chilton, probably going to the same court appearance. Mr. Avery was going to, right? Yes. Okay, and the best way from Chilton to Manitowoc is Highway 151? That would be correct. And I'm not going to get into your routes of travel, but in any event, Mr. Avery was going to Manitowoc from Chilton for a court appearance? That is correct. Okay, did these three women wave to Mr. Avery, or what exactly did they do when their car was nearby? I know they made contact, but again, I know that the officers felt uncomfortable with this vehicle following them, and also felt very uncomfortable when the vehicle pulled up beside them and they realized who it was. All right, when you say contact, there was no physical contact made? No, visual. Visual contact, okay. So Mr. Avery is in the sheriff's car, and the three women are in one of their cars? Right. All right, you're not aware of Mr. Avery saying anything at all in your custody to try to arrange their encounter, are you? We haven't been able to determine how the arrangement was made. All we were informed of is that they waited for the vehicle to pass while they were parked at the Quick Trip in Chilton, and then proceeded to follow the vehicle from that location in Manitowoc. All right, if there were arrangements, and if Mr. Avery had been a party to them, you would have a recording of that, wouldn't you? I would hope so, yes. All right, and those have been listened to, and there's been no evidence that Mr. Avery was part of any arrangements that may have been, right? That I'm aware of, yes. Okay. Did Mr. Avery try to escape when he saw these two elderly women and Jody Stokowski in the car? No, he did not. Did he do anything inappropriate at all? Not that I'm aware of. Do you think someone would have told you if he had? Yes. Did the two elderly ministers brandish weapons or try to run the car off the road or do anything overt? No. Okay, it was just, they were a feeling of discomfort. Yes, they were informed that we did not look favorably upon that, and that it would not happen again or action would be taken. And they were informed of that later, but not much later, correct? Not much later, no. Right. It was within a day or so. Somebody spoke to the minister or the minister's assistant, said that you are not going to be coming up and waving at Mr. Avery, right? Yes, Lieutenant Burns took care of that, yes. Okay, that didn't result in an arrest or anything like that, just a warning? A warning, yes. All right, Mr. Avery didn't have to be warned about the incident because he didn't do anything, right? He was in custody and he was not warned, no. I can't say that he wasn't told that we didn't appreciate that. He may have, and I'm not aware if he was. Oh, sure, I understand, but he didn't take any action that required any sort of discipline or warning of him. That is correct. Do you understand, just so that we're on the same page, you understand that nothing in my motion is intended to have any impact at all on your jail, correct? That's correct. Or on transport of Mr. Avery anywhere? That is correct. Okay, you understand that my motion is talking only about things that happened in the courtroom? Yeah, I understand that. Okay, thank you. Attorney Strang, that's all I have, Your Honor. The court. Mr. Kratz, do you have any questions? Attorney Kratz, just 2 points of clarification. Cross-examination by Attorney Kratz. By Attorney Kratz. Question. As I understand, Sheriff, you brought someone with you here today who can describe in better terms than you the use of the stun belt, and if there's any questions of the court as to how that might, not only in theory, but in practice, work in this case? Answer. That is correct. The deputy that I have brought with me has been trained by the company in the use of the stun belt, and he, in turn, is a trainer of other jailers at the Calumet County Sheriff's Department. Lastly, for a point of clarification, since I'm not really asking questions to make a record, the arrest on the 9th of November of Mr. Avery, was that for what's called a statutory offense, that is, having been a convicted felon who has possessed a firearm, not an arrest for homicide or any related charges. Is that right? That is accurate, Attorney Kratz. That's all I've got, Judge. Thank you. The court. You may be seated. The witness. Okay. The court. Mr. Strang, are there any other witnesses you wish to question? Attorney Strang. I don't need to question anybody else. I'll be happy to argue the point, and I would move the admission of Exhibits 1 and 2. The court. Any objection to the exhibits? Very well. They are admitted. Mr. Strang? Attorney Strang. Well, first of all, within the broad limits that the Constitution or state law may require, I'm fully in agreement with the proposition that sheriffs should run jails and sheriffs should have a good deal of latitude in being responsible in deciding how to handle prisoner or detainee movement. The motion really goes no further than proceedings in a court, and indeed, it's a little bit narrower than that. Proceedings in a courtroom when the jury is present, or potential jurors may be present. So I'm not asking this court to superintend security arrangements or the handling of Mr. Avery or anyone else in custody beyond proceedings for which the court itself, not the sheriff, is directly responsible. And I've come to know a little bit, Sheriff Pagel, in the last year, and have been impressed with his thoughtfulness and his candor and the way he's treated defense counsel. That said, I don't think that the record here rises anywhere near the level that would be necessary to justify a stun belt or any similar restraint being used, in this case, in a courtroom in which jurors or potential jurors are present. The Illinois Supreme Court's list of considerations, I'm sure not intended to be exhaustive and not adopted at all by any Wisconsin court so far as I know, nevertheless, are pretty useful and cover a lot of things that a court reasonably might consider here. The seriousness of the present charge is given. It's a serious charge. The defendant's temperament and character we have heard some general stuff about. Nothing that suggests any specific risk in this case or to any person in this case. And the court itself has had an opportunity to observe Mr. Avery directly when he is in court. Now, since November 2005, and we have been here a number of times, and I'm certainly aware of nothing menacing or inappropriate or ill-behaved that he's ever done in court. So I think that's a positive factor here on balance, or at very worst a neutral. The defendant's age and physical characteristics Physical characteristics. He is not particularly young. He is not highly muscular or sculpted or physically huge, someone who's a great deal larger than the average law enforcement officer or the average human being for that matter. His past record, he has a past record. It's less lengthy than many people the court sees parade through here or sit at counsel table, including many who are not restrained in a stun belt. There's no record of past escapes or attempted escapes by Mr. Avery, and indeed, Sheriff Pagel was candid enough to tell us that since November 9th, 2005, there doesn't seem to be any planning or any effort by him suggesting an intention to escape. Any threats by the defendant to harm others or create a disturbance, there's nothing as to creating a disturbance. And the only threats we have, it turns out now, I guess, were made by the defendant's father, not by Stephen Avery, and his response was to laugh. That's hard to gauge as between father and son, and we've all been, or at least the men in the room, have been in the position of being a son at some point in their lives. And for myself, I know I have. During his lifetime, I laughed at some of the things my father said, rather than get into an argument or a confrontation. So it's hard to put much weight on that conversation, particularly where the threat, if the threat it was meant to be, as opposed to venting or hyperbole or just inappropriate show of support and anger on behalf of one's son. It's hard to put any real weight on that, particularly where the question is not whether Alan Avery should be in a stun belt, but whether Stephen Avery ought to be in a stun belt. We don't have any evidence of self-destructive tendencies of the defendant. There doesn't seem to be any risk of mob violence or attempted revenge by others. And it's worth noting here that the Halbach family and their friends and supporters have been, at all times, while I've been around, entirely well-mannered, dignified. Absolutely nothing coming from the Halbach family that would suggest that they have any intention other than respecting the dignity of the court, respecting the human dignity of the people in the courtroom, Mr. Avery included, and conducting themselves honorably as they have every minute they have been here in these proceedings. And I would extend that to anybody I've seen sitting on their side of the courtroom, so to speak, whether those are friends or friends of Teresa's, more distant relatives. I don't know who they are, but I haven't seen anybody in this courtroom on either side, honestly, who has caused any problem or behaved inappropriately in any way that I know. And I have been in past murder prosecutions, and I'm, as this court probably is aware, when that kind of tension is in the air. It just hasn't been here in this case. There's nothing to suggest a possibility of rescue attempts by other offenders still at large. The only person the state contends to be another offender is himself in custody. The state's been pretty clear that, at least as to third-party actors, there's one and only one that they think there even would be appropriate evidence about. And as I say, he's in custody. I understand I'm putting myself in the shoes of a law enforcement officer. I can understand why one might be uncomfortable about a car appearing to follow on the way to court and in pulling alongside at the red light or whatever it was. But, the reality here is this turns out to be the Right Reverend Granny Clampett and her septuagenarian sidekick and Mr. Avery's girlfriend. And nobody does anything, apparently, other than wave or look at Mr. Avery, and he does nothing at all. So again, even if this were showing sufficient to put Granny Clampett in the stun belt, it doesn't warrant putting Stephen Avery in one. And it's worth noting there that, Mr. Avery's every word is listened to. And as the court knows from prior motion, he's not having contact visits with either of these two ministers. These are through the glass, and they are tape recorded. So the Calumet County Sheriff's Department, or some investigator on this case, would know if Mr. Avery had participated in some planning for this, car incident on the way to court. Size and mood of the audience, again, I already covered. It doesn't suggest restraining Mr. Avery. The nature and physical security of the courtroom is actually very good in Calumet County. The jail is right down the secured hallway. I expect there will be deputies in the courtroom. Spectators are going through a magnometer, so no one is going to pass a weapon to Mr. Avery or use a weapon against him. Not that a stun belt on him would help allay that concern in any event. So I think, in the end, the adequacy and availability of the usual alternate remedies, which is to have bailiffs, and we have 2 case agents here rather than just one, both of whom I expect may well be armed during this trial, really more than suffices here. Without going into the gruesome details of the cases, I include enough in my motion to make clear, I think, that what we're talking about with an 8-second, 50,000-volt jolt to the kidneys is electrocuting someone. It's not intended to be lethal, but similar devices have been. The law review I cited collects some of that information, and it's almost common sense to understand that cardiac arrhythmia or other problems could be caused by this. People defecate involuntarily, not infrequently, when these things are activated. They urinate on themselves involuntarily, and they are incapacitated, not just for the time of the jolt, but for a long time after. You have a mistrial is what happens, I think, when these things go off, or at least you have a serious mistrial issue, which the Ohio Supreme Court had to deal with, and ultimately affirmed the trial court's decision not to grant a mistrial. But it was a serious issue. And the manufacturer of the REACT device at least advertised it as something that gives law enforcement total psychological control over the person wearing the belt. Well, when he's on trial, facing life in prison, and trying to decide whether to testify, trying to assist counsel, trying to confront, in the constitutional sense, the witnesses against him, an accused has the right not to be under the total psychological control of his adversaries. And sitting there fearing that if he says something wrong or does something that a sheriff's deputy doesn't like, or just by accident, since accidental activation of these devices are well reported in the cases, that this device will go off and incapacitate him. So we're talking about a very serious device here, and something that is intended and only can be expected to have a very strong psychological impact on the person wearing them. Has a psychological impact on me wondering whether, if I happen to have my arm around him when this thing goes off, whether I, too, will be knocked to the floor and lose control of my bowels. I just don't think there's a record here that warrants it in a courtroom. And a courtroom is the only thing we're talking about. The court. All right. Anything from the state? Attorney Kratz. Very briefly, Judge. Mr. Pagel reminds me that the kind of belt that Mr. Strang is alluding to is not the kind used by the Calumet County Sheriff's Department and can be inquired further should the court need to do that. I would ask the court take judicial notice that only of Mr. Avery's criminal history, but the pleadings in this case, including our other act's motion, would note that not all factors that Mr. Strang has alluded to are of equal importance when considering the security issue. Obviously, the seriousness of the offense, the facts alleged in the complaint, his history of violence, all the state believes are more important than whether a 70-year-old woman waved at Mr. Avery at some point in the past. And finally, would point to the court to the appellate decision of State v. Russ, R-U-S-S, decided in 2005. And I know that's a shackle case, not a stun belt case, but does, when at least complaining about some due process violations, place upon the defense a burden of proof that there be some actual prevention of communicating with their clients in order to establish that there's been some deprivation on a constitutional or due process level. That's all the comments I have. And once again, Judge, we'll defer to the court as to the court security issue. Thank you. Attorney Strang. And I certainly have no objection to the court taking judicial notice of the files in this case, or for that matter, of Mr. Avery's prior record. The court. All right, I'm going to take a minute. I'm not going to take it today, but I'm going to go back and look at the other act's motion. It's been a while since I've looked at it, and I will give the parties a decision next week. I think that wraps up our agenda for today, does it not, counsel? Attorney Fallon. If it does, I did want to clarify one point. I'm sitting here thinking, and I don't remember how the final answer came out in our discussion with Mr. Buting on the bones. And I don't know if he's going to prepare an order or not, but just so it's clear that any opinions regarding what's human and what's not human, or whatever, the only opinion on that is going to come from Dr. Lisenberg, and that the only thing that the FBI mitochondrial report says that we weren't able to determine any mitochondrial identification as that may pertain to the issue of human or non-human or animal or what have you. So, those are the only two entities that could offer any evidence vis-a-vis that particular question or issue. And so it's whatever the report says. So I just wanted to be sure. I can't remember how we left it, but I didn't want to leave anybody with a misunderstanding of what may or may not come down the road. It's all in Lisenberg's report. The court. That's my understanding or my recollection. Mr. Buting, does that square with yours? Attorney Buting. Yes. The court. All right. We're adjourned for today. Mr. Kratz? Attorney Kratz. What time did you want us here on Monday? I have forgotten. The court. We're going to start at 8:30, so try and get here around 8:20. We'll start with bringing a juror in at 8:30. Attorney Strang. Where it's here. The court. Here is going to be this courtroom. We're adjourned for today. Attorney Kratz. Thank you, Your Honor. Proceedings concluded.